All right. Welcome. I'm Stephen Colby, and welcome to my seminar on how to protect your intellectual property. I want to start off by thanking Rob at Idea to IPO for organizing this event. He does quite a bit of events. Please check out his very frequent emails. Get on his email list, and there are an awful lot of things that he does for startups, some of them by my colleagues. Right, so I am a patent attorney, and I'm the type of patent attorney that mainly does prosecution. That means I write patent applications, I submit them to the patent office, and on behalf of my clients, I try to turn them into patents. There are other types of patent attorneys that do litigation, right? The big fight, stressful job. I do about 5% of that in my time. So it's a good mix. Being a patent attorney is a lot of fun because I get to see the coolest, greatest technology first, often even before the investors. So I enjoy it a lot. I have been doing patents since the early 90s. I've been doing it as a patent attorney or patent agent since about 2000. So the first few years was as on the inventor side. I spent most of the 90s as the CTO of a chemical instrument company. So I have a very strong product manager type background. I'm really a product guy at heart. And I love going to trade shows and giving presentations and things like that. I was just at CES in Las Vegas. I will be at South by Southwest in Austin coming up this spring. So I hope everybody has a chance to visit there. My email is going to be part of the, let me share the screen here. You are welcome to contact me on my email. Boom. There. Okay. You should all see the slides. Very good. Now, let me just bring this up. Come on, why can't you expand? So I have, oh, here we go. I have both, the Q&A tab is open. So if you have any questions during the seminar, please put your questions there. I can see that tab here, but I can't see the chat tab. There we go. Okay. So I can see the Q&A tab. I will probably wait until the end before I answer any more questions, but if something comes up that's especially pertinent, please put it in the Q&A. I will probably blabble on to you for about an hour, and then I will turn my attention to the questions, and we'll hopefully finish up in an hour and 15 or an hour and 20 minutes altogether. And please feel free to connect with me on LinkedIn. I'm easy to find. You should be seeing my email information on the screen right now. You can reach out to me and ask questions by email if you prefer. I do want to remind you that listening to this seminar doesn't create a, doesn't make me your legal representative, right? So that requires some paperwork and an actual engagement agreement in the state of California. I'm a California attorney as well as a USPTO patent attorney. All right, well, let's move on. We're going to be talking about how to protect your intellectual property today. And this presentation is going to be directed at early stage startups. So for example, people who are just starting a company or who are planning to start a company, that is the audience that this presentation is directed at. It's a lot of fun, and there's a lot to starting a company. One of the things I like to say is the cool idea is probably about 5% at most of the whole thing, right? All the work, hiring people, relationships, your investors, getting a product out, having a scrum, all those things are the other 95%. And so we're going to just talk about the intellectual property part, although I will talk a little bit about employees and other things like that today. All right, let's move on. How do we change this button? Click. Okay, the first question that comes to mind is why? Why would you do this? You're a struggling startup, you don't have any money, or maybe you have a little bit of money and it's Aunt Mary's, okay? Why would you put thousands of dollars into a patent portfolio? And I see people asking this question, um, all the time. And I see them sometimes giving wrong answers to people. So you're not going to do IP because it's going to be the big golden shield against all your competitors. The fact is that to enforce patents, and I have one litigation case that's going on right now, it is over 7 years old, okay? It is costing in the multiple millions of dollars, roughly. So, and if you are an early stage startup and you start enforcing patents, you will transform into a patent enforcement company. There's no way to do both, grow your startup and enforce patents. It takes years between the filing of a patent application and for the patent to issue, usually, unless you pay some extra fees. So the real reason that you want to have a good IP portfolio, including patents and trademarks and trade secrets, is to increase the valuation of your company. Okay? If you don't learn anything else from this seminar, that's the one thing that I want you to remember. Intellectual property for a startup, the purpose is to increase the valuation of the company. The valuation is really important to you. The valuation determines how much equity you have to give away for money, right? On your exit, the valuation determines how much money goes into your pocket. Now, I've seen cases where, there are multiple companies being looked at by an acquirer, and the one that had a really good patent portfolio won out, right? The others died. I mean, they went to nothing. One company was in the many hundreds of millions, and the others went to their investors, to creditors. So it can make a really big difference. Having a good, strong patent portfolio makes the difference between if you want to be acquired by, let's say, Microsoft or Amazon. Having those companies look at what you're doing and say, oh, we could throw 100 engineers at this and reproduce it in 6 months. That'll cost us $2 million. Well, maybe not quite that little, but that'll cost us some small amount. Why should we pay $100 million for the startup, right? And they'll run spreadsheets. But if you have a good patent portfolio, then that changes the mathematics of the spreadsheets, right? It means this company is more valuable. It has these assets. And if we try to just work around it, there's a 30% chance, 50% chance that someday we'll get sued and it'll cost us many millions of dollars in the end, right? So just this week, Google got sued by a company that had had extensive talks with them. And the suit is $1.6 billion. Okay, that will certainly go down. But that's an example of a company that thought they were going to do a great deal with a major acquirer. And instead, Google hired a bunch of staff and engineers away from the startup. Okay, and what's left is a patent enforcement company. So that's not the way you want to go. It's no fun. It takes many years. Having done startups, I can tell you that just takes away your feeling of accomplishment. It makes you just angry. So get a good patent portfolio. The reason is to increase the valuation of the company. And if I do my job right, every time you raise money, I've paid for myself many times over because the patent portfolio has really helped. Okay. So we've been talking about IP. Let's talk a little bit about what you can get. What are you going to try to protect? So there's lots of different IP, right? Madonna has IP in her personality, in her image, right? That's different. That's not what we're going to be talking about now. For an early stage startup, the most common IP are copyrights, trademarks, trade secrets, and patents. And you can't see it, but I'm counting on my fingers over here, okay? So just take my word for it. Copyrights. Copyright protects things like your website, the layout and the words on your website, the bios of each person listed on the website, each executive team member, the words that talk about your product. Those words are and the layout of the website, that's protected by copyright. Other things that might be copyright are your source code and compiled code. So those are things that are protected by copyright. And somewhere in all your code, there should be a little statement that says copyright, my company name and a year, right? A little text string, okay? So copyright doesn't protect, it doesn't protect the basic idea. So let me give you an example. I can have a copyright on a still life of a painting of a bunch of fruit, right? So that particular rendering of fruit is what is protected by my copyright. I don't have the rights to any painting of a bunch of fruit, okay? That's the concept behind the piece of art. That is not protected by copyright, okay? It's only the particular representation of the idea. And if, let's say, you're a software company, your code is copyrightable, but the copyright doesn't protect the functionality of the code, what it does. Somebody can take that code or take your ideas, ignore your code, and rewrite it in a different language with, from scratch. And the copyright doesn't protect the basic underlying idea, okay? That's going to be for patents. We'll talk about that last here. So the next thing is trademarks, right? Trademarks protect your goods or services, and they are associated with the goods and services, right? So if I am Apple, I have the little Apple symbol. That's a trademark. It's associated with my business and the services Apple provides and the products that they make, right? The iPhone, that word is a trademark that represents that particular phone. iPhone doesn't represent the company as a whole. So the trademarks are things that your salespeople that are in your sales literature, the marketing people, the things that you use to convey a mark to identify your products and make sure that consumers aren't confused. This is a big word in trademark law. They aren't confused between your products and services and somebody else's, right? So one thing you can do with trademarks right now is you can take your product name and you can put a little TM, that's a little capital TM next to the corporate name or the product name, right? So use that now. It gives you some initial rights. Write down the date that you first start doing that, okay? And that gives you common law rights, right? Later, and you don't need to do this right away, you can file for a trademark application, right? In most countries, the trademark rights go to the first person to use it. There's an exception, a couple of exceptions, China being one, being the big one, where it's first to file, right? So start off, before you spend money on a trademark, just put a little TM by the mark you're using and write down the date that you first started using it in commerce, okay, on a website where somebody can buy and sell something, right? Or ask for some service, okay? That's trademarks. Trade secrets is something that, by definition, you keep secret, right? It's something that you actually make an effort to keep secret. And trade secrets can be really valuable for a company. One of the things that really increases their value is if you actually have a trade secret program, right? You might read in the papers, oh, so-and-so suing somebody else because they stole their employees and those employees took trade secrets away from them and so on. In that type of suit, it really helps if you have documentation of what your trade secrets were. If you're trying to put that together, oh, our automatic braking algorithm for our scooters was a trade secret, and you try to establish that after the fact, after you think it's already leaked, that's really hard. What you want to do is you want to have almost a literal binder with pieces of paper in it and saying, these are our 10 valuable trade secrets that we protect. And you keep that binder in a safe with your other important documents. And you actually have a program in place in your software stack or in your corporate communications. You limit who actually gets to see that trade secret, right? So when an employee gets access to that algorithm, the best thing is they have to sign a separate little piece of paper saying, yes, I acknowledge this is a trade secret. I think that's always good because they're very likely to remember that. I always feel sorry for the engineer who 5 years later goes, oh, I think I did this once somewhere, and they have no memory that that was really important to the other company, and they're going to cause a lawsuit, right? So trade secrets are good. They can be really valuable. There's a lot of things, some good things to trade secrets to get trade established as trade secrets are things that aren't patentable. Right? There's a lot of things that aren't patentable, and we'll talk about that in a minute. But if it's non-patentable and it's not easy for somebody else to discover, and it really makes important thing for your business, then you should really sit down and consider setting up a trade secret program. And this is really inexpensive. It's a couple of hours with an attorney at most, and you can get off the best ROI, the best return on anything pretty much, other than the little TM. That's pretty good. So the last thing we're going to talk about is patents. And of course, being a patent attorney, I'm going to spend most of my time talking about patents. It's what I know and do and love. Patents can cover lots of different things. They can cover types of plants. They can cover methods of doing things. They can cover mechanical devices, surgical equipment, semiconductors, healthcare apps, software, all kinds of stuff. Probably about 70 to 80% of the patents I do are software related. They have something to do, a lot of those are apps, right? I have a phone full of random apps from all these clients of mine. I've done things like keyboards, virtual keyboards for phone, healthcare apps, software that does analysis of ultrasound. I have a client that does communication software for cameras that you swallow, right? And it does a video of your insides. And my client's specialty is not the camera itself, but the communication software so that a person can do this at home on their own without having to go to the hospital to do it, right? Those are the types of things. Patents cover lots of cool stuff. Personally, I'll talk a little bit about my law firm at the end, but I do just about everything but drugs. So my PhD is in analytical chemistry, which is a field of chemistry that builds instruments. So a lot of electronics, a lot of software programming, robotics. When I was in industry, I built sample handling equipment and material processing equipment and robotics and things like that. So my background is really broad. I did lots of work on lasers and chemical instruments and material science across the board. I have other partners that do pharma, right? I leave that for somebody else. Ramon actually we're a law firm of about 230 people, 230 attorneys, and about 20 of those are patent attorneys. So we pretty much do everything across the board that you could want. All right, let's talk a little bit now, dive into the patents. This is the exciting part, right? Yay. Okay. Jim has a question. I'm going to answer that at the end. Let's go to the next slide. All right. So common types of patents. These are the types of patents that you are likely to run into as a startup, as an early stage startup. And this isn't quite correct, this slide. These are types of the first two listed here, the provisional and non-provisional, are actually types of patent applications. I should reword this. So a provisional application and a non-provisional application eventually, hopefully, will turn into a utility patent, right? This is a patent that covers a device that has some utility or a method of doing something, right? A design patent is restricted to the ornamental features of something. So you could do a design patent on a tire tread or a hubcap or a really beautiful lamp, right? So a lamp base that has intricate carving. So design patents can be useful. The example that I always give is the, what they're called, the speakerphone, Polycom Polycom's triangular speakerphone. It used to be that I would be giving this discussion not over Zoom, but in person with somebody, and often there would be the speakerphone sitting on the table. Well, it turns out that in Polycom's early years, it was founded by two electrical engineers, and the patent attorney they used was also an electrical engineer. So they did a bunch of patents on noise filtering and the duplex capabilities and so on. And they also did a design patent on that triangular shape. And it turned out the design patent was the most valuable patent they did starting off. That shape is really good. The alternatives on your conference room desk, like a UFO saucer disc type phone, that looks really big and bulky and not as sleek. So the design of the Polycom speakerphone was a great example of an early design patent that really became valuable. All right. Let's go now to the provisional and non-provisional. These are types of applications. The provisional application is something that's very often used by early stage startups because it basically puts a stake in the ground. It's quick and easy, inexpensive, right? You can, if you have a white paper or a requirements document, you can put a cover slip on that and file it as a provisional. There's some cases where you might take a article you're about to publish or even a slide deck and put a cover sheet on it and file it as a provisional. I'll explain why you might want to do that. One of the most important things about a provisional patent application is that it only lasts 1 year. That's a hard deadline. After the 1 year is up, it goes away unless you file a non-provisional patent application, and that can be a U.S. national phase application, or it could be some type of international application. You have to do it within that 1 year, and you have to reference the provisional and make some legal statements saying, we claim priority of this provisional application. Very often, a non-provisional application will include several claim benefit of several provisional applications, because over the preceding year, the company's done a bunch of development. They've gotten some more money. They've built up and made that provisional application stronger, right? The disadvantages of the provisional, other than it only lasts 1 year, is that it can often be very, what's the word I want to use? Thin, right? If it's just your slide deck, that's not really going to be enough to support claims in a later full patent, non-provisional application, right? So when you do your provisional, you want it as meaty as possible. You don't want to file 3 pages. You want 30, right? You want to describe everything that you might think is going to be important in the future. You're looking 5, 7, 10 years out. Okay, where will my product be then? That's the type of stuff you want in the provisional application. When I do provisionals, I write a set of claims. They're not required in a provisional application, but I write a good set of claims, and then I absolutely make sure that there's enough in that document to really support those claims, so that I know that I've got enough support for something eventually. Okay. The non-provisional application is what hopefully will turn into a patent. Okay. And that can take a few years, right? What happens is you file it with the patent office, and these days it really depends a lot in what field you are, right? If it's software, it might be a little longer. Semiconductors, not so long. In maybe a year, the patent office gets back to you, and 95% of the time they reject your claims. They say what you're asking for is unpatentable for various reasons. Either it's obvious, or it's certain types of non-patentable subject matter, or it's been done before. Okay, so those are the types of rejections you can get, and you have 3 to 6 months, depending on the extension fees you pay, to respond to that office action. And a typical patent, on average, goes through like 1.9, meaning about 2 office actions. Those cost money, right? And we'll talk about money in a bit. All right. Hopefully, And it can cost a lot of money. I mean, you can go to appeal, you can go to court, you can fight tooth and nail with the patent office if you really want to, right? Usually that's not a great ROI, but if it's important, it's possible, right? The non-provisional application has two cost phases: getting it ready and filing it, and then these office actions. And it's hard to predict how many office actions you have. It also depends really how broad you want your claims, okay? The non-provisional application lasts 20 years from the filing date of the non-provisional. The design application lasts 14 years, right? The provisional itself isn't counted in this term, which is a good thing. So in effect, you can file a provisional application exactly 1 year later, a non-provisional, and you can get 21 years of coverage out, okay? So we've been talking mostly about, I did have mentioned international just once, okay? The big question that clients come to me with is, will I rule the world with my patents? I want to patent I'm so important. I want Vietnam, I want Taiwan, Malaysia, I want the Congo, I want Ivory Coast, Libya, really? Okay, so you're not going to get a patent everywhere. That, maybe some drug companies do that with their billion-dollar products, but really your focus is going to be, if you're going to go outside the United States, your focus is going to be on where your major markets are, right? The top 2 or 3 markets, where your competitors are, right? If you have a competitor in Belgium, hey, you might decide eventually to get a patent there. If you have, and the final criteria is who's going to buy you? What's your exit plan, right? If you expect to be bought by Samsung, or that's a possibility, then you want a patent in South Korea. So this is the way to track. Those are the things that make you choose to file something outside the United States. Now, at the end of, if you file a provisional first, or if you file a non-provisional first, 1 year after your first filing, you have to decide if you're going to go outside the United States or not. And there's fortunately something called a PCT application that stands for Patent Cooperation Treaty. And all that is basically an option that gives you another 18 or 19 months before you have to choose individual countries or regions, right? So in a typical situation, somebody will have filed a provisional application. A little less than a year later, they can file a U.S. non-provisional, maybe, or a PCT application. The PCT application in some countries gives you 19 more months, in some countries it's 18 more months. And at the end of those time periods, then you have to file individual applications in Japan or Korea or Canada or Australia. There are some regions, the most common is the EPO, the European Patent Office, which gives you most of Europe. So you can file an application there. After it's approved, then you pick the individual countries and it's automatically registered in those countries. So you might, here's the tale. You start with a provisional, 11 months later, you file a PCT application. 18 months later, you decide to go into the US. Yes, you can go back into the US. You go into the EPO and you go into South Korea. Let's say that's what your decision is. Now you're prosecuting, this is expensive because there's lots of translation fees and costs, and you're dealing with your patent attorney and also these foreign patent attorneys, right? Because I'm a US patent attorney, I'm not an EPO patent attorney. So a few more years down the line, I've lost track, but we're like 4 or 5 years out now, right? And you're paying plenty of fees on this. So foreign filing and getting foreign patents is expensive. And you also, once you get them, you have to pay an annual fee to keep them alive in different parts of the world. So if you're successful at the EPO and you decide you want France, Germany, and Belgium, or Denmark, or the Netherlands or something, then you're going to be paying for patents in each one of those countries every year, right? So by that point, you've probably already done your exit, and it's somebody else's problem, right? But that's the whole multi-year path to getting coverage outside the U.S. You will not get I have seen companies in the early days, the dot-com boom, try to do lots of patents, and they were like software for doing foreign exchange or something like that. There was a reason that they were doing Egypt and Saudi Arabia and South Africa and so on. The other clients that I have do a lot of interesting countries are in ag tech, right? So I have a client that does insect control technology. They use pheromones and all kinds of cool stuff that's non-toxic to control insects. And so they're really interested in Argentina and Chile and Turkey, right? So those are the types of places we end up getting patents for them. So if you're in a special niche, maybe. If you're in mining, then the US, China, and Australia, right? So it depends. So yes, you won't rule the world, but the fortunate thing is you don't have to make a decision for a long time. 30 months after your provisional filing date is when you have to decide if you're going to go outside the US at all. And that option, that PCT application, typical cost for that, the filing fees are about $3,000. Your patent attorney should be less than $1,000. So you have an option there. You don't have to worry about that right now. Okay, let's move on. Wow, when should you do this? Yesterday. Think of the Beatles, okay? IP is one of the first things you should be thinking about, right? There's a bunch of reasons, like if there's a group of you, there's co-founders, right? You have multiple inventors. And we'll talk in a few minutes about how inventorship impacts ownership of the IP. You have people contributing to the company, right? And some people are going to contribute sweat and hours of labor. Sweat, right? Sleepless nights, right? Some people are going to contribute ideas. And of course, some people contribute a mixture of those things. So in your early decisions about company ownership and planning and all the things you'll discuss with your corporate attorney, the IP is definitely something to consider. It is very advantageous to at least get some filing done before you talk to investors, right? You might, again, I said, I don't want 3 pages, I want more. But your first filing might just be 3 pages that cover everything you're going to communicate with an investor. It could be a slide deck. The thing about investors is most of the time you talk to investors, it's not considered a confidential communication, right? If it's at a pitch event, it's definitely not a confidential communication. And that makes a difference. We'll talk about that in a minute. And the first thing a good investor does is he talks to his buddies who've invested in similar companies. He says, I've got this really interesting opportunity, but I know you invested in this one. What do you think of this? Right? That's what they naturally do. Okay. So if you're going to deal with an investor and you have issues about like something you want to keep a trade secret, what you'll do is you'll write a narrow NDA that covers just that one little thing. You'll show them everything else, and then you'll have a slide that says, to see this, you have to sign this NDA. It lasts for only 2 years, and it's not a big deal. Investors hate signing those because they see so much deal flow. It's impossible for them to remember where what came from, right? It's just, a VC can see 1,000 deals a year, right? So doing something like signing an NDA is only when you're way deep into the due diligence of the investment, right? When they're close to committing to you, will it be worth bringing that up? Another big factor is in the US, if you make something public, meaning you use it publicly or you present it in a publication in a white paper, you put it on your website, you have 1 year to file your patent application. You have a grace period of 1 year. Okay. And in the meantime, you have to kind of worry that somebody's going to take that idea, make an improvement, and do some their own filings. So file first, right? The other important thing, even more important, is that in most of the world, there is no grace period. Once you use something publicly, that use is prior art against your patent application. Prior art meaning the examiner can use it to reject your patent application, saying, oh, this was discussed at this conference. Here's a white paper that explains everything that was a month before your patent filing, if this is the EPO or Korea, they're going to cite that presentation or that published paper and knock out your patent application. Right? So if there's any chance at all you plan on filing overseas, file first, file a provisional, if nothing else, right? That is the reason why you might take something as thin, as weak as just a slide deck and put it in a provisional patent application. So if you're going to do a presentation, I'm going to be at South by Southwest. If you're going to present your technology there, do some filing. The purpose of that filing is not to really support a great future patent application. The purpose of that filing is to make sure you have a filing date before the public use. Now, let me add one more comment to this. Public use doesn't mean it has to be really clear to the consumer. So if you have let's say a treadmill that lets somebody walk in any direction while they're doing VR, I have a client that does this, right? And you show that at a trade show, and your really cool predictive algorithms are running on a server in the cloud somewhere or on a computer there at the show, and the user can't see that, that still counts as public use of the entire back end, right? So if you have an app that's a healthcare app and you're demoing the app, that counts as public use of all the back end logic, right? It's a great story. This law, right, of like what is publicly used, comes from a case from the 1800s where some guy designed a corset with whale bones in it, and he put it on his wife, and she wore it out in public, and nobody could see the corset. They couldn't even tell, that she had one on, but that corset changed the shape of her figure, and that's considered public use, right? So that now applies to that case applies to software now, and so be careful what you're showing people, right? There's a few exceptions that you should talk about with your patent attorney first. If there's experimental testing, in some cases, if you do it right, that can be give you an exemption. So if you are a company that's testing asphalt on actual roadways, but you have to do it just right. You actually have to be doing experiments and testing. Okay? And that exemption may not work everywhere, right? So you might have to deal with Japanese law, and maybe it's different there. I can't tell you. So I have another question, a short question from Jim, and I'm going to answer this one right now. He's asking, should I wait to file or reduce to practice first? File first. The technical term reducing to practice, a really good description, 30, 40 page description of the technology, that counts as a, quote unquote, a reduction to practice. I can tell you, having spent many years as a CTO and as an engineer, it's so much more fun as a patent attorney because I can write in like 3 hours what it would take somebody a year to implement, right, and design and build. It's so much more cool. Sorry, guys, folks. File first. So take your design and what you plan to implement. What you think, especially make sure you write about the really new distinguishing features, why it's better. Put that out there in a provisional. Now, it could turn out that in 3 months, that whole plan is out the window, right? You've decided to go a totally different way, and that you might just forget that provisional. You might never claim benefit of it, and if it goes away as if it was never filed, it's never made public, right? It's confidential, right? You might cite it in a non-provisional along with a bunch of others, just so that you have. Then that keeps those ideas alive, and it'll prevent other people from getting patents in that space, right? Competitors. File first, write it up, file it, and then what's very common is you'll file a provisional application that's really, let's say, 5 pages thin, and 3 months later, you'll have made a bunch of progress in your development, and you'll then add 10 more pages to that document, and you'll refile it. You'll get the second filing date, credit for the second filing date for everything new that you added, right? And then that might happen let's say a couple more times before the end of the year. And then you've built the document up to like 40, 50 pages. And you say, okay, now I've got this great non-provisional specification, this application I'm going to file. It covers it has all the stuff from the provisionals in it. And I'm going to reference all 4 of them. And so you get credit for each filing date of the provisional of like, when did I first present this to the patent office? And basically you're putting stakes in the ground, and that's the way to go. The first provisional is very likely not to be the last. So I have a client on Monday who has like 6 provisionals, and I know what my weekend is going to be. It's going to be packaging all those together, put them in, and it's an AI, right? It's chat GPT related. There's a lot of cool stuff we filed last year, and it's all going to go into one big giant patent application. So yeah, file first. All right, now I have been mentioning costs, and I'm going to do something now that most attorneys won't do. But it's important for you because I've done startups, right? And I know that money is one of the big considerations here. So how much is all this going to cost? And I am a patent attorney. I'm based in Reno. I'm a California attorney. My clients are all over the world. Most of them are in Silicon Valley, so I spend a good deal of time in the San Francisco Bay Area. So this is a typical example, and I've done some sampling of clients of what it's cost, right? You probably can get something less expensive. I say that hiring a patent attorney is like buying a car. You can buy a Yugo, and it will last a short amount of time, and it was really expensive, but it's really not worth it. You can buy I used to pick on Jaguar, but let's still pick on Jaguar, even though they're not British anymore. You can spend a lot of money on a really fancy car, and it still doesn't work very good. A Camry will go 300,000 miles and will be a good car for the price, right? So there's a certain amount of you pay what you get, but not completely, right? You've got to find somebody who's experienced. You want to find somebody experienced in your area who really understands not just your technology, but your business goals, right? So let's talk about costs. Okay, here's an example. So let's see, this looks about right still. I have to update this every once in a while. So if I do a provisional with you, you can do a provisional on your own. There's a book called Patent Pending in 24 Hours by Nolo Press that's like $40 or $50. You can get it at Amazon. And you can do it on your own. If you work with an attorney, which means that it's more likely that provisional will really have enough to it, will not have any serious mistakes in it, will adequately support later patents and non-provisional applications. I do a flat fee for $2,500. And what happens with that is we spend an hour or two with a disclosure meeting. Where you explain to me all your technology, I then go write a summary, a set of claims, which is what we think is going to be important. And then I give you an outline that's kind of based on the claims and tell you to fill all that in. I want you to write all the details. This is not a lot of money because I'm not spending 30 or 40 hours writing it. Okay, I'm spending 2 to 4 hours total, somewhere in there. Yeah, 3 to 4 hours total. And so then I file that, put a cover sheet on, file it, right? In a few months, we come back and we say, okay, what else have you developed? And we do another one, right? I like that approach because it's a good compromise between the buying a book and doing it on your own and me really spending a lot of time and a lot of cost to you in developing a full patent application when you're at the bootstrap stage. When you have raised money, if you've raised $1 million, that changes things completely. Then it's usually we'll split things. Sometimes we'll do provisionals. Sometimes I'll write everything. depending on your bandwidth, right? Because it takes your time. Okay. So a provisional takes about 2,500. A non-provisional application depends on the size, right? A 60-page is more than a 30-page, right? Of course, a 60-page application has more meat to it. There's probably more things in there that are really important and valuable. Okay. A very rough estimate of how much that's going to cost you to prepare is about $18,000. Okay. It can vary 15 to 20 maybe. But that's the type of money you would think about putting in as a budget. When I have a startup come to me and they're raising money and they say, how much should I budget for IP? And I say, well, after your first real round of funding, after your seed round, a pre-seed round where you get $500,000 to $1 million, you could conceive of putting $30,000 to $50,000 in your patent budget, right? Or your IP budget. You might get a trademark and a non-provisional and several provisionals in for that amount of money, right? That's good. So after you file it, as I mentioned, there's these office actions. The patent office is going to go back and forth and back and forth, and those cost $5,000 or $6,000 a piece because the attorney has to prepare. And this is again, sometimes it's less than 1,000, right? Sometimes, 1 out of 20 times your claims will be allowed right away. Okay, and that number will go from 30 down to 1 or 2, right? Because there's some fees, some issue fees at the end from the patent office. So that's really hard to predict, but fortunately, it's years out there, right? It's a couple of years after your early provisional filing. Now, there's a second line here, the pink line on the lower part. That's for family members. So we haven't talked much about it, but a patent application can have a family of daughters, right? So I might write a really nice 50-page specification and get a set of claims out of it and say, okay, there's lots of stuff here that we haven't covered in our claims, right? We wanted to get a patent, so we didn't go too broad. We found something narrow to focus on that's important, but easy to get the claims issued on. And now we're going to file a daughter application, either called a continuation or a continuation in part. And the continuation in part means we could add a little more disclosure to it. And we're going to make the daughter has to be filed while the parent is pending. And that daughter will have a different set of claims, right? And so it's very common that one initial filing will end up a dozen patents in the end, right? That'll be your core filing, and after the seminar, I am filing a patent application where the initial provisional was filed in 2004, 2005. Okay, and it's like, it's less than 20 years, so there's still a reason to continue filing for this particular case. I'm about to do that. So the cost goes down dramatically. I have looked at a portfolio where a client has done a whole family of patent applications, 10 or more, and the cost drops to get a non-provision on file it's more like 9,000 to 12,000 instead of 18 because we're constantly reusing material. All right, so that's it. Now let's talk about some of the critical issues about your portfolio that's important for you to keep in mind. One of these is ownership. Okay, and I have a whole separate seminar I give on the 5 most critical mistakes or critical issues. Ownership is really important. In the US, ownership initially invests in the inventors, okay? That inventor is the person who contributed to the conception of what's in the claims, not in the specification, right? I just told you could have an application, a daughter application with different claims, and that might mean that those two applications and those eventually patents have different sets of inventors because it's what is in the claims that determines the inventorship. So sometimes you might look at somebody else's patent and go, oh my gosh, all this stuff they're writing is old hat. How did they get this? Well, you got to look at the claims. There's something in the claims, and it might be one paragraph in this entire document that really explains that new little bit, but that was enough to get it past the examiner and get a patent, right? So if the ownership is initially in the inventors, you actually have to do something to get it assigned to the company, right? Typically, this will be an assignment clause in a employment agreement or in a founder's agreement or in a contractor's contract. So let me give you an example. If you use a cloud source thing like Fiverr, right? When you post your job, there is a checkbox that says, will I own the IP of what this person's going to generate? If you're having somebody design a logo for your company, or you pay somebody $25 to send you 20 different possible logos, and right? You better check that box because they still own the copyright to that logo. Okay? There has to be really careful. Make sure that everybody you deal with that you can has an assignment clause, right? And an example I like to give is Adobe Forms. Adobe Forms is something we all use, and it's really cool. Well, it was invented by a sales guy, not an engineer. A sales guy at Adobe said, hey, we ought to have these fillable forms. And hopefully he had an assignment clause, right? Or they paid him pretty well. So make sure there's assignment clauses. Everybody, including you, right, will have a duty to assign to the company. And when I say including you, I mean your investors had better, if they're good investors, they'll do their due diligence and make sure that all the IP is owned by the company. Okay. You want to make sure that the rules for what you can assign to the company depend on state law, right? So California is much more protective of employees than Florida is, for example. In California, if you are a semiconductor engineer and you invent a new type of lawnmower, it's probably not possible for the employer to say, oh, that's part of our business, we own it. Florida is different, right? Florida could be much more broad. They can put an assignment in there. I'm not a Florida attorney. Mind you have to ask your Florida attorney. You have to be much more cautious because I have seen cases, for example, where a company making AR/VR headsets, we won't name the company, has an employee leave that starts a robot company, robotics. And the headset company says, oh, well, we use robots to build our headsets, so we own everything in your new company, right? So you got to be careful, got to know what state you're in, got to know where your employees are, right? If your employee is a Idaho resident or a Georgia resident, it can make a difference. If your employee is a resident of India or China, you're dealing with transfer laws out there. So you have to have a good idea. You have to actually know where your employees are, okay, and your contractors, right? So the next thing is, so make sure assignments are in place. The assignment can be a separate document that they sign after the invention, but there should be an assignment clause in whatever written agreement they have with the company. And that assignment clause is something that should be reviewed by a patent attorney. Right. Open source. There's a lot of great open source utilities out there. There is, what time is it? Okay, well, I'm running behind. Sorry, I'll go a little faster. There's open source out there, but you have to read the license agreement, right? Some open source software says that if you use our software in your product, you also have to make your product open source. And this happened to a former president of ours a couple of years ago who started something called Truth Social, and they used open source software and hadn't read the agreement. And once they launched, the open source committee wrote them a letter saying you have to make your entire code open source. So they had to pull the whole product off, and it took months later for them to rewrite everything and get it back up. Bad mistake. Okay. Make sure you're aware of the assignment process. Just like when you buy real estate or land in the United States, there's a recording statute where a document has to be recorded, and that recordation is a public record that everybody can look. Who owns this patent or patent application? They can look at the public records at the U.S. Patent Office and say, oh, it's this person. All right. And so all the assignments, once something is filed, You want to make sure all the assignments are up to date and the ownership is clearly in the company's name. Okay, moving on a little quicker now. Strategy. Okay, this is where I'm, being a product manager at heart is important. Patents are for the marketing team, right? What are patents for? Remember, increasing your valuation. That means pitching to engineers. I make a really good slide deck or a slide for your slide deck. If you're doing your A round and you're raising 5 million, I will work with you to really represent the patent portfolio in a really positive light. The patent is for the marketing person to say, we are the only ones who have this, blah, 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 blah. You want to patent the things that are important to sales and marketing, that sell your product, not necessarily the things that the engineer thought was a cool invention. And there can be a difference here, all right? So when you decide what to patent and you're talking with your patent attorney, make sure that you're thinking about this business side of things, right? Not the engineering, okay? It's got to be product driven, right? And you focus on the valuation of your company. As I said, I can do a nice slide for your slide deck in a few years down the line that shows the important features of your technology in a what's called a cluster map. It's in bubbles on a PowerPoint slide. And then all your patent applications are around that with lines drawn showing which patent applications apply to which important features. And it makes like a spider web. The point is to really convey to the person watching your presentation the value of the patent portfolio, right? Because that will make the patent portfolio click and make it more than just a checkbox. And this is an example, this phrase here, this tagline, make IP more than just a checkbox. I could put a little TM after that and, call it my tagline, right? And that doesn't cost me anything, right? So make sure that your patent attorney understands the business. That's the key takeaway. All right, we got just a couple more slides here. Other people's IP. If you're an early stage startup, and I'm a PhD scientist, so I was taught to read the literature. I tell my startups to read the literature. You should know what your competitors are doing. You should track them. You should see if they're filing patent applications that are eventually published. You should know what's in their space. If you work for a big multinational, if you work for Intel, don't read the literature, right? Talk to your employer's patent attorney. And the reason is that if you become aware of something for those companies, it can raise the risk that there will be higher damages in litigation if they're sued for patent infringement, okay? But as a startup, you don't want to spend 2 years of your life and your team's life working on something and only to find out that somebody's had a patent on this for 5 years, right? And some investor brings it up and you in a pitch and you go, oh my God, right? I'm not going to get this investment and I'm going to lay off everybody in a week, right? Know what's out there. And reading other people's stuff can give you ideas, right? You look at this competitor and you see their patent application and go, they're doing it wrong because we have this one trick that makes it all better, so much better, right? And then you file a patent application that includes their technology plus your improvement, right? And you just block them from incorporating that improvement. And that's valuable. That's where we get, feisty even. Patent attorneys are usually pretty passive. We don't box much, right? Anyway, the last thing I want you to do here is keep records. Every meeting you go to, the person calling the meeting is somebody should be keeping notes. Whose idea was what, right? And I am running out. What time is it? Okay, I'm going to give this last story. So if you are in a meeting and you have a cool idea, and it was Andy and Susan's idea, and you write down in your notes, either in the computer, which you're going to store on the server, or in your notebook. Good CEOs carry notebooks, and I sit down with them, and they open up and they start writing as soon as I start talking, right? So you've had this cool idea, right? Let's say improved automatic braking system. I'm into that today, okay, for some reason. And you write it down, and that's great. You don't do anything with it. It's like an idea, and you add it to your idea list, and 3 months later, you hire a new employee. Okay. 2 years later, you're sued because that new employee had worked for somebody who had had a trade secret on an automatic braking system. Right now you have, and they have great records of the trade secret, and that employee never told it to you. Right, he was good. Right, but you now have a problem. You have to defend yourself and show that, oh no, this was our idea, but you kept notes. You have a notebook with 3 sentences written. Andy and Susan came up with this new algorithm on automatic braking. It does this, this, and this. That is like the most valuable set of sentences, right? I mean, that saves you at minimum hundreds of thousands of dollars. Okay, so keep records, and you also have a record of who had what idea. Sometimes it's groupthink. I mean, everybody in the room can brainstorm for 20 minutes and come up with one idea, right? And it's everybody's. They've all contributed to the conception, right? Keep good records. It will help you with every part of your business. Okay, we talked about some of the mistakes. I have a separate seminar that I'll probably give in a month or two on going straight through these. We talked about ownership. Make sure you own your IP. Make sure you don't get IP from somebody else, right? Trade secrets from another company, open source stuff. Don't wait too long before you file. Only covering the things that engineering is keen on and not marketing. Have an actual strategy that matches your product plan. And the 5th thing is understanding the patent. And I have a separate seminar where I go through a patent and step by step and explain what is the detailed description for? Why are the claims so important? What's this priority claim listing in the front of it? Okay, you should have your patent attorney spend 30 minutes with you going over a patent application, explaining all what it means, right? And that is important because as CEO or as a CTO or as a founder of a company, you need to understand what the value of your IP is. And when you look at somebody else's patent and you see a specification that has all kinds of stuff in it, but you know to flip to the claims because that's the part that matters, that really explains what the patent covers. There could be lots of disclosure in the specification that has nothing to do with the claims, and the claims could be super narrow, right? That's what they really have a patent on, okay? And it also will let you decide, oh, this is what the claim says. We don't do part of this. The patent attorney will help you read the claim and say, oh, we don't have to worry, or we do have to worry about this claim, okay? Right, so now I'm gonna wrap up. Let me do one more slide. Hey, there we go. All right. Currently, so Ramon is a special law firm. We are a non-traditional law firm. We are one of the oldest and biggest, about 230 attorneys. We're actually, I think, now in 12 countries because our Russia office, 2 of our Eastern European offices, countries closed. So this number varies quite, a bit. I'm pretty sure it's 12 now. We're special because we're a semi-virtual law firm, and we're not a pyramid structure. So most law firms have a few partners at the top, a bunch of middle partners, and then armies of associates and newbies and fresh out of law school kids that do the work, right? We aren't that way. We are almost all senior partners, 20 plus years experience, right? And there's probably 10 times more partners than there are associates, roughly. The reason that is we have offices. So we have an office, I'm associated with our Truckee, that's North Lake Tahoe office. Our San Francisco office and our Menlo office I also use sometimes. Those offices are pretty small. They have conference rooms, maybe an admin or 2, and some offices, shared offices for attorneys. But most of the attorneys work at home. And this means that we avoid the biggest cost factor to law firms. It also means I can work in Mountain View occasionally, or in Tahiti if I want, or Hawaii, or in Reno, right? So it's great working for a semi-virtual law firm because it has all the support. There's a huge cost savings, so we are generally 20 to 30% less expensive than the big law firms, right? Who are pretty expensive, the competitors. That's our advantage. We do everything, lots of corporate work, FDA regulatory compliance, privacy policies, employment, real estate. We can do your divorce if it's in certain counties. We can lease you an aircraft, right? So it is a full service law firm with offices stretching from Dubai to Tokyo to Singapore to Hong Kong, all across the world. Anyway, that's it. I am now going to spend a few minutes going over the questions. Again, there will be a recording available. And let's drag my Q&A over. All right. Okay, I'm going to stop sharing the screen too. Hold on. There we go. All right. That's more comfortable. Jim asks, can discussion of your upcoming patent application in something like a ChatGPT session become disclosure under patent law if it's used to train ChatGPT? So communications with ChatGPT aren't confidential. So for me as a patent attorney, I couldn't use ChatGPT to write a sensitive portion of a patent application. I occasionally use it, and where I do use it, I would also use Wikipedia. So I'm going to give an example. I used ChatGPT sometime last year. I had a patent application that had to do with trimming sails for sailboats, and there was active material in the cloth, these smart wires. Okay. So I typed into ChatGPT, tell me all the smart materials that can be used to change the shape of a cloth, right? I knew this would be okay with the client, so that was not a problem. I didn't disclose that it was a sailboat. And they gave me a list of materials. And I also probably went to, I don't remember, but I probably went to Wikipedia and searched smart materials and got a list there and took that whole list and put it in the provisional, right? But I could use it to write a one paragraph background. Like, give me the state of GPT, right? And it would give me a paragraph, and I could throw that in the background. Nothing, it's all prior art, doesn't matter. Now the question of whether it's prior, that's public use. So while it's not confidential, like I can't share stuff that would be critical to a patent application with OpenAI, because that would be a violation of attorney-client privilege. There is some expectation of that they're not going to publicly share the queries. Although what I'm reading is more and more people have figured out how to get ChatGPT to actually regurgitate exact things that it was used to train with. So who knows? The question of would it be public use is the question would come down to, was there an expectation of confidentiality? And I would probably, as an attorney, err on the safe side. I would have to go look, Jim, into your specific case. If a session is used to train, I don't know. I have to look in your specific case. But I would be careful. Sit down with a patent attorney and go over exactly what you're doing to figure it out. That's probably the best bet. I answered your question about when to file. Yesterday. Okay. Don is asking, you have a existing patent expiring in 5 years that covers part of a functionality addressed in a new invention. How does that impact the new filing, or can we somehow incorporate the existing patent to streamline the process? So if it's already an issued existing patent, you cannot, it's prior art. If it's still a pending application or it has a pending daughter, like I told you, I'm dealing with a family that's from the 2004-2005 time frame, right? We're looking almost 20 years, right? if you have pending application, then you can claim priority back, right? So that's a reason to have always keeping things alive with pending applications, especially if it goes into litigation, you need to tweak the claims and change just a few words. That can be really valuable. So if I have clients with big patent portfolios, we always try to keep at least one thread of applications alive. But Don, it sounds like you have an issued patent. The criteria for getting a new patent will be, is the new invention, the new innovation, really non-obvious over what you had before, right? And so you want to try to cast it and write about it in a way that makes it look really different, all right? Anonymous, hi there. You're at every one of my seminars. Okay. What if the other party says they have notes that contradict yours? Well, then it's a fight, right? It's a lawyer fight, and getting hit with a trade secret theft probably is, you're going to go to a litigation attorney. We have those, and they'll probably ask for 50 grand right up front as a retainer. So that's the damage, right? It could be that both companies independently came up with the idea, but that, in the example I gave where they're accusing you of having stolen the trade secret, all you have to do is show that you came up with it. Maybe they came up with it later. That's fine. And if it's now in the public, it's no longer a trade secret. But your defense is, we came up with this independently of you before we even hired this guy, hopefully, right? It could be after you hired him. But anyway, this is the type of keeping notes, helps keep you honest, helps keep other people honest, right? Okay, so great question. How can notes be verified as legitimate? If you have a document handling system, that's good. I have a personal Yahoo account that I have used, and I have used in litigation, right, on one of my patents. I have a few dozen patents. And it carries. Yeah, so I have emails that I sent to myself, 10, 15 years ago, 20 years ago, that are on a Yahoo server. Be careful, because nowadays, if you don't log into your Yahoo account for a year, they wipe it. Okay, so send it in an email. Have a regular company log that's timestamps. If you have a document handling system, again, it'll timestamp files going in. Sending it to a external email is a record keeping process. So I personally, after I do my taxes, I send that record to a email location, and I have personal record. It's like my filing cabinet, right? And that stands up because I can prove, like, I didn't get into Yahoo's or Google's personal, internal things and change the date on an email, right? I probably could do that in Outlook, but it would probably get caught. I mean, I don't know. In the old days probably, but no, it's that's the type of thing can establish things well. Yeah, send the email to the other. Here's the notes. I do this sometimes. So if I'm a board meeting, or like I'm on the board of a charity, after I finish my notes, I send a copy to everybody, right? So now it's not just me, but it's me sending. Okay, so that's how you can make sure notes are legit. Some people, back in the old days, I had real bound notebooks in the lab. My first patents were when I was a grad student and as a postdoc. And we had written documents in a notebook that had been notarized, that had been witnessed by somebody else, somebody over in the machine shop, right? He'd signed and witnessed it. And then we had computer records on the university servers of me doing a simulation of the invention in math lab or something like that. And, literally there was a time when these big attorneys, and they're kind of heavy guys, and their ties, suit and ties, right? This is the Midwest. They wore ties. They're sitting there and they're looking over the computer screen, and we're bringing up the files, and they look at the code and they say, okay, right? That made it. That did it. Okay. Because someone can create a set of notes, but it's hard. As I said, get things witnessed by independent people, like the machine shop operator, who's not working for you at the university. he's building the thing, right? Um, use email service. You can timestamp stuff in Adobe, right? These days. So those are all ways you can do things. You can digitally sign it. Send it to yourself in Adobe and digitally sign it. That's probably pretty good. Right? You'll come up with something. Yeah, deepfakes. We'll see. So one of the interesting areas, how much time do I have? Okay, 13 more minutes. One of the interesting areas I'm working in now is crypto. Not crypto as in currency, but cryptography. Um, uh, the new computers, the quantum computers, are going to be able to break the encryptions used like on Bitcoin that are currently being used. So the those all have to change. It's going to be interesting. So there's a lot of technology being developed. There's new algorithms, and you can go to NIST, that's the National Institute of Standards, or to ISO, and there's new algorithms for doing cryptography that are supposed to be quote unquote post-quantum, meaning that they will still stand up to quantum computers. Cool area. So yeah, it would be a lot of trouble to like forge a signed Adobe, a DocuSign document with, and DocuSign is going to have a record of it too, right? So not only do you have the document yourself, the signed copy, but DocuSign is going to have a record of making this thing. So it would be hard to mess with. Yeah, I think keeping good records is pretty good these days. Okay, last Adele asks, an NDA is a non-disclosure agreement. And so that's a signed agreement saying I'm going to receive some confidential material. Sometimes it's two-way, sometimes it's just one way. You're going to receive confidential material, and they agree not to disclose it to anybody else. Preferably, it has a deadline. It expires in a year, 1, 2, 3 years, right? It's a burden on somebody to sign one that's going to last forever, right? So you have NDA is a non-disclosure agreement. Okay, Jim's final question. If a startup uses something like Microsoft Copilot in writing code for a patentable invention, does that jeopardize the patentability of your invention? No. So that Microsoft is not supposed to go into the code. Okay, there's a strong expectation of confidentiality there. The same with Slack, right? Or other GitHub, right? That what you have privately stored on GitHub is supposed to be confidential. Of course, it could get hacked, right? Or some, rogue employee might figure out who's married to your competitor's whatever drug dealer. Might dig down and try to do something. But yeah, those things, other than hacking, I think you're uncomfortable. No. Well, here's a question, Jim. If you build an AI to design, and this has been done, to design better battery chemistry, you're MIT. You design an AI to develop and design and produce better battery chemistry, and it comes up with a new chemistry, and you file a patent application on that. Is that patentable? The current law is probably not, right? So in copyright, they've addressed this. They've said, okay, this is an image produced by an AI. It has to be a human person to produce it. They haven't addressed, oh, the human started with this and the AI just tweaked it. So there's in the next 5 or 10 years, there's going to be lots of litigation over AI-generated intellectual property. And this is literally a case. MIT has developed a technology, an AI technology, to improve battery chemistry. And I don't know if I was an examiner, the examiner probably will reject claims that are in part developed by an AI. So this is an interesting area, and I expect it'll swing one way, and then there'll be some. So the example is I wrote the really great prompt Don't I get credit for that, right? Wasn't that part of the invention? Anyway, yeah, we don't know how AI and inventions are going to work, or IP. Video is a bit fuzzy. Recording would be helpful. Yes, within a week, everybody should get a copy of the recording. Yes, non-disclosure. Yes, good. Steve is asking, when patenting a software for architecture document design, should we file a different patent for the same topic for every part of the system? Noise. Now, to start off, you're going to have one document, disclosure document, and you'll grow that document over time. You're filing daughters and CIPs and so on. You will probably start off by focusing your claims on what you think is the most important part of the most important invention in this document. And you'll not be too aggressive on your claims, so it'll be easy to get the patent out. So you get your first patent. Then you might file one daughter that's on the noise filters, and you have a set of claims that on the noise filters are supported by the document, right? You have to have the stuff there, right? And then you might have another patent that you file it's around the same time, the sister, that's going to focus on have a set of broader claims, right? That give you more patent scope, but will be harder to get through the patent office because you're going to spend more time arguing with the patent examiner and more back and forth. So sometimes what will happen is you'll get a patent application where you have, and that's the next thing I'm going to do, right? You have 5 claims that are allowed and 5 that are rejected. And you say, well, I could spend another year fighting over this, or I could just take what I have allowed, get a patent, and then take the ones that are rejected, and literally I'm going to do this next in a few minutes, take the ones that are rejected and file a daughter application, and then fight about those another day. That is a very common technique. So you can focus on different aspects. And as the portfolio grows, and I'm going to stop within 6 minutes, I promise. As the portfolio grows, you'll get an idea of what features the examiner can't find in the prior art, right? And he's like, this limitation, a battery with silicon in the anode, but the silicon is between 5 and 25%. And apparently that's nowhere else. Nobody else came up with that. But that range turns out to be important. And well, you put that limitation in every claim and you're going to get allowance. And then things work really well. So, okay. Most venture capitalists will not sign NDAs. No, they will not. So this is what happens. So if you have a really critical trade secret, and I work with a venture capital firm. If you have a critical aspect, you will talk about everything else and you'll say this is a trade secret, right? This algorithm or whatever. And then before they write the check for 10 million, then they'll sign the NDA. Right? Because now it's not one of 1,000 companies they're seeing. This is one they're actually committed to, and they're going to know your children's names. Okay. So yes, you can say to them, here's all the cool stuff. And we have an algorithm that does this. We have a secret sauce. We have a really cool filter that improves our data before we do the training of the AI. And that filter, we can show you what it does. I mean, what it does, but not how it does it. If you're going to invest in us and we're ready to sign off, then we'll have an NDA and we'll disclose that to you. Okay, so that's the process. But generally they will not, and I wouldn't if I were them, right? So attorneys are different because if you go to an attorney for a legal question, and this is US, that creates attorney-client privilege. Even though you're not a client, if I'm at a cocktail party and somebody says, you know, I was picking mushrooms and this afternoon my wife ate some of them and died, and I think I might be charged with involuntary manslaughter, what should I do? That conversation, because they're asking for legal advice, is immediately they get the benefit of attorney communication, even though they have not signed an engagement letter, and I wouldn't consider them my client. If you go to an attorney asking for legal advice, you get state protection, which is stronger than any NDA, right? The attorney can be disbarred and all kinds of horrible things can happen to them, right? NDAs can be hard to enforce. If you sign an NDA with somebody in Singapore or Vietnam or India, yeah, good luck. Okay, so be careful. I don't believe in NDAs so much. It's much better to file patents. Um, no. So Adele's asking if you write software in PHP code, is that considered open source? No. No, the code, the language itself isn't necessarily. It's the code. You might get a copyright on your text on the code you've written, but as far as I know, PHP doesn't require. You have to look. I'd have to look into exactly what their license said to use that, and I doubt. Well, look at your attorney you should look at what the license says. Okay, anonymous. If we use a virtual assistant or a programmer based overs, what if they steal your IP? What workforce do you have? Okay, you hopefully have filed patents. All right, so you can file a provisional with the requirements document that you're about to send the overseas programmer. Okay. You can work with a friend of mine from grad school has one of the largest code writing entities in India, right? And their clients are Microsoft and Amazon and so on. There's thousands of employees, right? And he's a very honest person, right? But you never know what some engineer is going to do. He'll give his brother an idea, or her brother, right? So file first. File that requirements document as a provisional, and then reference it in a non-provisional, and that gives you a date. That puts a stake in the ground for you, right? You need to have employees. Some of them will have spouses that will steal the computer and run off to South Africa, and you'll never see, right? So things happen. If you filed IP, that gives you some backstop. It gives you some protection, right? You are not going to sue somebody in India, right? Unless it's a company and they're big, right? You might sue Tata, right? But yeah, your recourses are limited. Yes, New York Times is suing OpenAI for use of their content. Your thoughts on how this will play out? I don't think this case will be the last. The amount of money they're asking for is kind of crazy. That's not going to happen. Developing AI is useful. I mean, I'm impressed with what ChatGPT does, and especially with the art. I have a friend who's the CEO of a music company, and she's a professor at Santa Clara University, and she has this great company that will write music and lyrics. You can give it a string of text and or a poem, and it'll write the score to it. It's cool stuff, right? And she's a former professional opera singer and a professor of computer science, right? And a CEO. So they do great stuff. It will be, I think, I don't know if I'm going to answer. Okay, how much time do I have? Okay, I'm out of time. Woo! No. Okay, I will answer your question. I think there'll be a lot more cases. I think that in copyright, there's a idea of fair use, and does using the text the New York Times put this out and published it for everybody to read. Okay, is actually reading it versus using it to train something. I mean, if I read it, I'm using it to train my mind. I mean, there's arguments on both sides, and I don't know where it will happen, but I bet that there will continue to be development of AI, right? This will not stop it because it's going to be such a big thing. And, they'll figure something out. It's like playing music on the radio, right? There's a little bit of money that goes to the artist, right? Same with Pandora. Like if I listen to something on Pandora, like a half a cent goes to 9 Inch Nails. Okay. So yeah, I think it'll be interesting. From the patent side, I'm more interested in artificial inventors, right? I think that the human who wrote the software should get some credit, right? It's still a cool invention. Anyway, I'm going to be doing I did lots of provisionals last year on ChatGPT type stuff, and I'm going to be doing lots of non-provisionals this year. It's really fun. Cool stuff. All right, folks. So that's it. You have my reach out, connect with me on LinkedIn. Check out Rob's other idea to IPO stuff. One of my former colleagues, Roger Royce, does great seminars. I highly recommend him. I also work closely with an organization called Pro Ventures, which is putting on some great talks. I will, let me type that in. I got to spell it right. I have a broken hand, so it's hard to type. Okay, Pro Ventures. Yeah. Yeah, they're doing great seminars, and feel free to reach out to me. Thank you very much. Have a good day.